Macy's versus knits. This is the example for the parole evidence rule that I mentioned in the video. So I want to go over, hopefully you had a chance to read it and work through the questions. This is the discussion relative to the example. So the Knits Corporation is a manufacturer of knitwear located in Capital City. Through one of its salesmen, it enters into a contract to deliver 1,200 sweaters to Mazie's department store, also located in Capital City. The written agreement contains specifications for the various numbers of sweaters to be delivered by size and color, but there's no language pertaining to how the sweaters are to be packaged for delivery to Mazie's. When the sweaters are delivered, Mazie is angered to find out that they are boxed according to size, with the colors all mixed together. She has expected them to be pre-sorted by color, which is much more in line with how she stores merchandise in her stockroom. So, first question. If Mazie was to complain and sue over this, would it be a sufficient defense on Knit's part if its distribution manager were to testify that the Knit Corp always packaged and shipped its products sorted by size? And then the next component of the question is, if this testimony alone would not vindicate Knit, what additional information would allow it to successfully argue that packing by size became a term of its contract with Mazie as an applicable trade usage? So here, the fact that Knits itself, well, first it's trying to use a trade usage component. The fact that it's always done this way, always does it this way, Knits does it this way, would presumably not be enough to establish a trade usage. As you know by the rule, it requires that the practice have such a regularity of observance in a place, vocation, or trade as to justify an expectation that it will be observed with respect to the transaction in question. So the mere assertion that such and such is a valid trade usage is not going to make it so. So what would Knits have to show to establish a trade usage? And how could they show it? First, of course, the attorney for Knits, counsel for Knits, would have to make clear on his or her mind exactly what usage was to be established, and particularly to what place, vocation, or trade it was meant to apply to. So Knits could argue that packing goods sorted by size is a usage within the sweater trade, or the trade of knitwear sellers, or indeed the whole clothing manufacturing industry. It could argue that it was an established usage within the realm of Capital City, or the whole country, or some identifiable area of commerce. Assuming, for example, that counsel sought to establish that Knits had followed a usage well established in the knitwear industry within the entire United States, what evidence will it need to present? Probably would need to find witnesses who could testify, who regularly deal within the industry, that testify to the effect that sorting by size is how it's always done. But they might have to testify regarding other statements that are done maybe a little less globally, maybe in Capital City, like I said. So you're going to need more than Knit saying this is how we always do it. They're going to have to go out and find others who regularly deal in such a fashion in that industry. So that's how the usage in the trade usage works relative to arguing that point when there's an open point or open term. So letter B. Imagine that Knits is not able to or chooses not to establish a trade usage to support its position. Would it still win if it could show that in the previous year it had entered into a similar contract for sales of scarves and mittens to Mazie's, and furthermore that Mazie accepted delivery of these sorted by size without complaint? Here, what's Knit trying to do? Trying to establish a course of dealing between itself and Mazie. The definition would probably fall short relative to the definition. Knits would lose because one prior incident would not be a sequence of previous conduct. Okay, so you need more than one dealing, but the code doesn't say how many you need. The UCC doesn't say how many you need. what constitutes how many prior incidences that are necessary to make up a sequence, but presumably we need at least 2. So even if SNITS could show that it entered into 2 or more previous contracts for scarves and mittens, and that in each case deliveries had been packaged by size, do you think Mazie has an argument? Sure. Mazie might still have an argument that this did not establish a course of dealing relevant to this transaction. All this evidence could do would to establish a course of dealing in scarves and mittens. Macy's would argue now we're talking about sweaters. Could a course of dealing in these other knits products fairly be regarded as establishing a common basis for understanding for interpreting their contract for the purchase and sale of sweaters? It would be helpful to know if practices and customs are generally the same across the whole larger knitwear industry, probably. So if so, then knits would have established a course of dealing covering this transaction as well. If for some reason, or if only by tradition, scarves and mittens are sold, packaged, and delivered in ways quite distinct from how sweaters are dealt with, knits would not have a course of dealing to go with. So you have to think those through when you're looking at these types of arguments. Suppose that knits is able to establish, this is letter C, suppose that knits is able to establish a course of dealing between the parties, that knitwear sales to Mazie is to be sorted by size. Mazie, however, claims that she was legitimately surprised because there was a general usage of trade that her manufacturers sell clothing to retail stores. The items are delivered pre-sorted by color. So Mazie here is trying to argue trade usage, and Knits is trying to argue a course of dealing. That's 1C. Who wins? Knit wins. It's course of dealing that controls over the usage of trade established by Mazie. That's how the hierarchy is formed, okay? So if there's a establishment of the party's course of dealings, a sequence of prior dealings, that will trump over any what's customary in the trade. So D, finally, suppose that the contract between Knits and Mazie called for a delivery of 1,000 sweaters during each month for a year starting in May. Knits made deliveries in May and April, which remained unopened in Mazie's storehouse. When the June shipment arrived, Mazie decided it was time to break out all the sweaters in anticipation of the winter sales season. Only then does she discover that the goods are not packaged in the way she expected. Is it too late for her to complain? She might have trouble complaining. Knits will claim that May and April deliveries established a course of performance for this particular contract. So if we're looking at the definition of course of performance, Mazie could argue here that she did not have knowledge of the nature of the earlier deliveries and hence had no opportunity to object to how the sweaters were packaged, but I doubt she'd be successful on that. If Knits has been making its monthly deliveries for some time and Mazie has not made any mention of the shape they were in, doesn't Knits have the right to claim that she accepted them without any objection? Could be. The language of knowledge and the opportunity to object obviously adds something to the definition of course of performance, but where as here, Knits would be reasonable to assume that having heard no objection to the earlier shipments meant that she at least agreed, right? Acquiescence to it. I think Knits wins. Perhaps the answer would be otherwise if Mazie could show that Knits would have or should have been aware that a buyer of the sweaters would not unpack any shipments made in the spring immediately, but would rather open them up when several shipments had arrived. But then what was the point, right? What was the point of the earlier deliveries? So that's how course of performance works. And 1E, would your answer to the previous question change if the written agreement between the parties contained a clause that read items to be pre-sorted by color? And the answer would be yes, it would change. If the express language of the written agreement calls for packaging by color, that should give Mazie what she wants. Neither usage of trade, course of dealing, nor course of performance will overcome the express agreement. So those are the analysis for the parole evidence rule example. Work through that. Make sure you understand how those components work.